You are listening to Based in Fact, a true crime podcast. Join hosts Lisa O'Brien and Kyle Evans as they examine America's most infamous true crime cases as they were established in our courts and the basis for the decisions of the appeals courts, not the court of public opinion. Here's Lisa and Kyle.
Welcome to season 2 of Based in Fact, a true crime podcast. I'm your host, Lisa O'Brien, and I'm joined by my co-host, Kyle Evans. In this bonus episode, Kyle and I are talking about the Texas Court of Criminal Appeals' recent denial and dismissal of Rodney Reed's -10 and -11 post-conviction claims, which was issued on June 28, 2023. Contrary to the false statements being made on behalf of Reed by Innocence Project attorney Jane Pucher and other advocates, the evidence presented by Reed was either not deemed to be credible or reliable support for his actual innocence claims, or was deemed insufficient to meet his burden of proof of his actual innocence, Brady, and false testimony claims, which were being brought before the court and in reality were in some cases being brought before the court for a second, third, or maybe fourth time with, quote, new information or, quote, new experts or a new iteration of the same old story. But we'll get to that a little bit more in depth in a little bit. It is July 3rd, and happy 4th of July. How did your time go between yesterday when we signed off and today when we're signing back on?
Yeah, it was nice. I'd got to do some pre-4th of July celebrating with some friends, so it was really nice.
Oh, good.
It is hot, but always a good time, yeah, to enjoy and get outside and enjoy the hot weather. But at least there was a pool nearby, so we were able to cool off a little bit as best you can this time of year.
Cool. Well, this
How
is
about
day
you?
3, and I have only stepped out of my house to get my Walmart grocery order on Saturday. I'm quite proud of myself for that. And I apologize if I cut you off.
No worries. Just saying hello and back to Rodney Reed again. This is
Yes.
just like we were talking about Glossop yesterday, much to the misinformation out there, like Glossop, Reed has certainly not had more than his fair share of justice and bites at the apple. So, the thought that somehow he hasn't gotten a fair deal is a little bit silly, given when you see all of the motions and writs, and many times he's been before the courts.
Correct. I totally agree, but his attorneys just won't give up. So, and what to me makes this one of the most egregious cases of innocence fraud out there is that there is overwhelming DNA evidence linking Rodney Reed to Stacey Stites' murder, rape and murder. Overwhelming DNA evidence. It's not just a few small sperm cells that were old and, were left in a consensual encounter days before. It's DNA on her breast, DNA in her panties, DNA found on her pants and back brace, and additional DNA testing done post-conviction. So, how much DNA is enough? And
right.
Yet they want to test the belt, and they're holding the belt out as the be-all, end-all.
Well, I was thinking the other day, I think it was before we recorded yesterday, I was thinking maybe this would be a fun episode we should do sometime. But, what are your what are the top 10 most egregious innocence fraud cases? I was just thinking through the ones that are the highest profile, but this one definitely has to be, if not number one, it's right up there in terms of just it's a real stretch to think, he's innocent of
And
all of these cases. His is right up there of just, you really have to do some mental gymnastics to buy what he's selling.
correct. And you have to look at it this way. For years, Innocence Project's main plan of attack was do DNA testing, don't find the DNA of the convicted person, argue that proves their innocence and gets them out of prison. And yet here they are, and they're arguing that the person who doesn't have a speck of DNA is the real killer, and the person who has overwhelming DNA, they just pretend that doesn't exist, or they lie about it.
Right. Well, and
So
I think too, let's be honest. I think part of the appeal for them, they are very savvy, right? Like they know how to package these cases up and sell them. And, here you have an African American man, convicted of killing a white girl. And then the latest, alternative suspect is not only a white guy, but a white former policeman. So it has,
mhm.
it has everything, all the elements to get unquestionable attention, from a lot of the media and social media out there where people dare not ask tough questions.
Yeah. I got it. And somebody is knocking at my front door. Let me do this. I'm going to pause the recording, folks, and I'm going to go and see what that's about, because it's unusual and I don't want to just ignore it. So I'm going to pause for a few minutes. Kyle, if you need to step away or whatever, I'll
Sure,
be
no
right back.
problem.
I'm back, and I think it was just somebody leaving a flyer. So, but
Gotcha.
I just didn't want to leave it if it was a neighbor or somebody needing something. All right, so we're back. All right, so let's get into a little bit of overview first before we get into the meat and potatoes. Of course, the crime occurred on April 23rd, 1996. The victim was Stacy Lee Stites, a 19-year-old woman. She left her apartment in Giddings, Texas at around 3 a.m. to travel to Bastrop, where she was due for an early morning shift in the produce department at an H-E-B grocery store. At some time during that drive, she encountered Reed, who abducted her, then raped and murdered her. Based on a statement from a newspaper delivery person, Stacy's body was placed off the side of a road in rural Bastrop County at some time after 4:00 a.m. The red pickup truck Stacy was driving was left in a parking lot behind Bastrop High School and was noted by a police officer at around 5:23 a.m. Stacy's body was found at 3:00 in the afternoon. Reed wasn't immediately looked at as a suspect in spite of his history of domestic violence and prior rape allegations, including a 1995 rape on the railroad tracks near the high school parking lot. It wasn't until he attempted to abduct another 19-year-old woman in the same area that led police to compare Reed's DNA to the DNA from Stacy's murder. In an interview on April 4th, 1997, Reed denied knowing Stacy. At his trial, he claimed a secret relationship with her, but presented two witnesses who were not found to be credible by his jury. He was convicted and sentenced to death.
And I think I know you'll get into this, but I think it's a good time to remind listeners that Reed had successfully played the secret relationship card before, right? I don't remember how much earlier, but I believe it
Correct.
was in Wichita Falls. He was accused of rape and claimed to have been in a secret relationship. So this is not, he's done this before and it worked. So not super surprising that he plays the secret relationship card.
You are correct. That was Connie in Wichita Falls. She was raped in August of 1987. Reed was arrested. He was linked to the rape. And then he did not go to trial until 1991. He was free on bail, where he raped a 12-year-old girl in Bastrop. And then when he was ultimately tried in 1991, he was acquitted of the rape because the jury chose to believe his claims of consensual. I have seen, although I can't corroborate it, I have seen at least one juror in a social media post, or someone claiming to have been a juror in that Wichita Falls case, in a social media post saying that they regret their decision to acquit Reed, because they feel that if they had convicted him, this would not have happened, because he would have gone to prison for a long time.
Right.
And Reed was not, a promising student or a promising athlete. He had gotten into boxing and he may have participated in a tournament, but he was not by any means a champion or consistently. I mean, I've searched the, Texas State Golden Gloves rosters for those years and don't find Rodney Reed's name on any of the major rosters. So, he may have won a regional or a local title, maybe, but he was not a star. He was not
He was
a
not Mike
promising
Tyson.
athlete. He dropped out of high school. And I've talked to people he went to high school with, and there's allegations that both he and Roderick were aggressive and inappropriate with young women during their time in high school.
Well, it
and
fits
that
the
there
pattern. I
are
mean,
perhaps
it's
some women out there who were sexually assaulted that have just never come forward.
right. Yeah, he certainly has the bad track record. I mean, this is not just a nice guy who is, happened to get railroaded by the police. I mean, I think it's worth double clicking too, because another one of the other, I think, sort of things that people say is, oh, he was railroaded. And again, it was 9 months later that he was even considered as a suspect. So it was not like they just went out and grabbed, the local African American man and, accused him. It was
Correct. And in fact, his name
time.
does appear on an early report because he was a suspect in Vivian's rape in 1995, October of 1995. But they didn't even talk to him. They didn't talk to him. They didn't interview him. They didn't seek biological samples. They didn't do anything until Linda S. My apologies. I try not to use these ladies' last names. I want to refer to them just by their first name and their last initial, because I want to try and give them, even though they've appeared, their names have appeared in court records, I just want to give them some semblance of privacy. But anyway, Linda S., he tried to kidnap her. She was able to escape. And I firmly believe that had he succeeded, she would have been found probably in the same area where he dumped Stacy. Her car was stolen and it was found in the high school parking lot, and he would have killed her as well. Because she was a fighter. And I think Stacy was a fighter. And I think Stacy either fought and hurt him or fought, hurt him, and told him point blank, my boyfriend's a cop, you're going to pay.
That makes sense.
So anyway, that's I don't want to digress too far off the path. Reed was arrested on April 4th, 1997, and he was arrested. He was questioned because his DNA linked him to the biological evidence found in and on Stacy's body that had developed an unknown DNA profile that had excluded Jimmy Fennell, David Lawhon, and every other suspect that they had been looking at for the 10 plus months until Reed's name came into it. Reed was tried in May of 1998, and he was convicted and found guilty of capital murder, 2 counts of capital murder, on May 18th, 1998. He was sentenced to death on May 28th, 1998. His direct appeal was decided on December 6th, 2000, and the appellate court held, even at that time, on his direct appeal. Given the strength of the DNA evidence connecting Reed to the sexual assault on Stacy and the forensic evidence indicating that the person who sexually assaulted Stacy was the person who killed her, a reasonable jury could find that Reed is guilty of the offense of capital murder. And concluding that Reed's other claims were without merit, we affirmed Reed's conviction and sentence. Now, that is taken from a later opinion summarizing the direct appeal opinion, which was unpublished. And I have a copy of it, but I haven't ever summarized it for the purposes of these case notes. Stay tuned because I will be doing that. So, Reed's conviction and sentence became final on October 9th, 2001, when his petition for a petition to the U.S. Supreme Court was denied, and that's when his conviction and sentence became final. So any question or reasonable doubt or whatever advocates want to call it, the time for that was at his trial. That is over.
Right.
He is now legally and factually guilty in the eyes of the law and the eyes of the courts. And, just because you think there's reasonable doubt or there's things at trial that should have created reasonable doubt, that's your opinion, but it's not worth the price of tea in China because it is your opinion and it has no legal or factual precedent as far as Rodney Reed's guilt or innocence is concerned. Rodney Reed has filed 11 state post-conviction writs. His first and second state post-conviction writs were denied in 2002. I do not have copies of those orders yet, but I plan on obtaining them as soon as I can. His third state post-conviction writ was denied in 2008 in December. His fourth and fifth state post-conviction writs were dismissed in January of 2009, as was a sixth post-conviction writ. His seventh post-conviction writ was dismissed in 2017. His eighth and ninth post-conviction writs, his eighth post-conviction writ, he did have some claims remanded and they were developed at a hearing, but were ultimately denied. And then his remaining claims on the eighth post-conviction writ and the ninth post-conviction writ were dismissed, and that all happened in June of 2019. And then in November of 2019, Reed filed a 10th state post-conviction writ, which was remanded for development at a hearing in the trial court. That hearing was held in 2021. The trial court issued findings of fact in November of 2021. And then in December of 2021, he filed his 11th post-conviction writ, which was forwarded to the Court of Criminal Appeals in December of 2021. That was not remanded. Nothing was remanded. That was just at the Court of Criminal Appeals pending their decision on the 10th writ. He's also had full federal post-conviction challenge. He filed a petition for writ of habeas corpus in the U.S. Federal District Court. That was denied on, I believe, June 15, 2012 by a report and recommendation by the magistrate judge. An order adopting the magistrate judge's report and recommendation was issued in September of 2012. That was appealed, and the Fifth Circuit Court of Appeal affirmed the district court on January 10th, 2014, and then his writ to the U.S. Supreme Court was denied on November 3rd, 2014. So again, that federal denial became final when his writ to the U.S. Supreme Court was denied. Reed did file a Chapter 64 motion for DNA testing in state court. He waited to file that request until July 14th, the date of a hearing, to set an execution date. How convenient. then the state and Reed did enter an agreed order for some limited DNA testing. And that was to test evidence held by the Department of Public Safety, and we've talked about this before.
Yep.
That was held by the Department of Public Safety in Austin, and the evidence was actually transferred to the Garland DPS lab, and it was the Garland DPS lab which performed the actual testing of the evidence, and that was done in several stages. And we recently did an exhaustive look at the DNA testing,
Yep.
so I'm not gonna replow that ground. But basically they tested the evidence maintained to develop whatever DNA profiles they could, and then separately tested the reference sample from Reed, separately tested the reference sample from Stacy, and then analyzed all of the results and basically concluded that Reed could not be excluded as a donor of DNA found on a lot of the trial evidence, or all of the trial evidence, and additional evidence, including Stacy's pants and back brace, which were not subjected to DNA, had swabs not subjected to DNA testing, because the presumption in 1996 was that the stains on the pants and back brace were Stacy's saliva. And they found that the swabs actually contained a mixture of DNA from both Stacy and Reed. And some people have said it was touch DNA from the pants and back brace, and that's not the case. These were swabs that were taken in 1996, but not subjected to DNA testing. And that could have been because of the presumption that it was Stacy's DNA. The defense did not request testing of those swabs, which they could have done. They had their own DNA expert. So, that was why. And it may have also been because there wasn't enough material to split between state crime lab and defense.
Right.
And so they didn't test something. I think they tried to limit their testing to things that would have enough to split for eventual defense testing down the road. But anyway, that can be more accurately developed by talking to the DNA people from the Austin DPS crime lab in 1996 who performed the actual testing. I'm just speculating as to why I believe those particular swabs were not tested at the time. There was also an agreed order to transfer evidence from the technical associates, which was Reed's defense DNA expert, to the Garland crime lab, but that dealt with only extracts, evidence samples and DNA extracts and reagent blanks for 2 hairs that were transferred via Federal Express. There was also an order granting Reed's request to transfer evidence held by technical associates other than those hairs to Cellmark Forensics. And that was done. There was an order then permitting Cellmark to transfer evidence to Bodie, I don't know how you pronounce it, but we've never heard what the results of that DNA testing was. And that would have included evidence samples from Vivian and the minor, AW, for those extraneous offenses. It would have also included crime scene evidence from Stacy's case. So, what's the deal, Rodney Reed? What's the deal? Because we should have heard about these results if you've got results that prove Jimmy Finnell's guilty.
Yeah, that's what I was going to say. You can kind of read between the lines that usually when there's DNA testing done by the defense and they don't scream about it from the, top of the world, you kind of know what it's telling you, and that it just continues to implicate the convicted.
Right.
Otherwise, to your point, they would have been broadcasting it everywhere.
And my suspicion is that all of that evidence only inculpates Rodney Reed.
Right.
And inculpates no one else. It doesn't inculpate Pat Barnett. It doesn't inculpate James Slaughter. And it doesn't inculpate Jimmy Finnell. And that's why we have not heard about it from the Innocence Project.
Exactly.
So in February 2015, the state filed an advisory and an amended advisory regarding that agreed DNA testing outside Chapter 64. And they basically found that Rodney Reed could not be excluded from DNA found on multiple items of crime scene evidence, including the original testing done in 1996 on the swabs, breast swabs, vaginal swabs, rectal swabs, sperm search slides, but also on the pants and back brace, which also included Stacy's genetic profile. And I was going to go through, but I must have taken the wrong thing out. Anyway, we'll probably talk about that a little more later anyway.
Yeah. Well, I mean, at the end of the day, there's his DNA is exactly where you would expect it to be if he had assaulted her.
Correct. And it's not just in one place, it's in multiple locations.
Right. Exactly.
That are consistent, not with a consensual encounter days before Stacy died, but especially the pants and back brace are more consistent with a non-consensual kidnapping,
yes.
rape.
Well, and that's what I
murder.
thought is, yeah, especially the back brace and the pants too, right? Because I mean, you would think, I mean, not to be too graphic, but if it's consensual, probably not wearing your back brace and you're probably, taking your pants off. Like, yeah, just those are the things that just don't make sense if you just think about it practically. Why would his DNA be on her back brace?
Yeah. Now, in April 12th, 2017, the appeal of the state denial of DNA testing lodged by Reed was decided by the Court of Criminal Appeals. And they basically held that the trial court did not err by denying defendant's motion for post-conviction DNA testing under Texas Code of Criminal Procedure, annotated Article 64.01, of over 40 items collected in the course of investigating the victim's sexual assault and murder, because he could not establish that exculpatory DNA results would have resulted in his acquittal and that his motion was not made for the purpose of unreasonable delay. So they affirmed the trial court denial of DNA testing. Reed filed a motion for rehearing, and that was denied on October 4th, 2017. The mandate issued on October 10th, 2017. Reed filed a direct writ of this, seeking review by the U.S. Supreme Court. He filed a motion to extend time to file his petition, which was granted on December 12th, 2017, giving him until February 1st, 2018 to file his petition. He did file his petition. He argued that the CCA's interpretation of Chapter 64's chain of custody requirement is fundamentally unfair and denies procedural due process and access to courts, and that the CCA's interpretation of Chapter 64's unreasonable delay element violates due process and because it is overbroad and assumes guilt. The state filed a response on May 7th, 2018, and their reasons to deny the petition were that the issues decided below are state law matters over which this court has no jurisdiction. This court's precedent shows denial is appropriate here. Even if the court possesses jurisdiction, and even if the issues presented had been properly raised and passed upon, Reed still fails to demonstrate a constitutional violation. He fails to prove that a chain of custody requirement violates due process. He fails to prove that it's unconstitutional to impose a diligence requirement, and the other findings affirmed by the lower court that Reed does not address would result in denial of DNA testing. The Supreme Court conferenced the case on June 21st, 2018, and they denied the petition on June 25th, 2018. Now, interestingly enough, he could have filed at that time a challenge in federal district court of Section 1983, but he didn't. He waited. And then when he had an execution date set for November of 2019, then in August 8th of 2019, that's when he files his federal complaint and demand for trial by jury, challenging under federal civil rights law 42 USC 1983 the state court handling of his DNA request. And I'm not going to go through those claims. That is also currently on appeal at the Fifth Circuit, or the dismissal of that is on appeal at the Fifth Circuit. So I'm not going to go through all that. But basically, he was raising many of the same issues he raised before the Supreme Court in the original writ, and a few additional ones. He amended that complaint on October 1st, 2019. An order was issued on November 15th, 2019 by the district court, which granted the state DA's, the Bastrop DA's motion to dismiss for failing to state a claim upon which relief may be granted, and denying Reed's motion for stay of execution, and dismissing the DA's motion to stay discovery, because Reed was requesting discovery. The final judgment for that also issued on November 15th. Reed appealed that decision to the Fifth Circuit Court of Appeal on December 13th, 2019. On April 21st, 2021, and of course we know Reed's execution in November of 2019 was stayed by the state court because of the writ filed in state court that we will be discussing soon. And the Fifth Circuit Court of Appeal, basically based on additional law provided by the state, found that Reed's request to the U.S. District Court was not timely, and held that he should have filed at least the deadline for him to file was 2 years after the state court denied his request for DNA testing, which would have been in November or December of 2014. He appealed that to the U.S. Supreme Court, and that petition was granted on April 25th, 2022. Oral argument was held on October 11th, 2022, and on April 19th, 2023, the U.S. Supreme Court, in a 6-3 decision, held that his civil rights claim was timely, and so the case is going back to the Fifth Circuit Court of Appeal, which is going to not look at the merits of the 1983 claim, and is not going to look at the merits of the DNA testing request, but is only going to look at whether the underlying federal court litigation was properly dismissed based on failure to state a claim. There is supplemental briefing that's going to happen in the Fifth Circuit Court of Appeal. Reed's supplemental brief is due today, but as of about 3:10 this afternoon, nothing had yet been filed.
Interesting.
So we'll have to see. And then the DA's supplemental brief is due, I think, 30 days from the date that Reed's brief is filed. and then the Reed can file a reply brief 21 days after the state's brief is filed. So now we are at the meat and potatoes of today's bonus episode, and that is going to be the denial of Reed's -10 and -11 state court writs. We'll look at the -10 writ first. This was the one that was resulted in a stay of execution because the court did find that some of the claims raised by Reed met the requirements to develop further with remand to the trial court. So the opinion or the order was issued by Judges McClure, which was joined by presiding Judge Keller, Judge Hervey, Judge Richardson, Judge Urey, Judge Keel, and Judge Slaughter. Then Judge Walker dissented, but I have not found an actual dissenting opinion filed by Judge Walker. So he doesn't agree, but
he hasn't told us why.
He hasn't issued an opinion on that. He just doesn't agree. And if I find a dissent, if a dissent is issued, I will certainly. But as usually those are uploaded by the Court of Criminal Appeals on the date the main opinion is issued. So
it just to go back, if it's not a 45-minute answer, but when you say for like a layperson, when you say like the request for supplemental briefing, what's due today?
Yeah.
Like what is like generally speaking, what does that mean?
That means he has until midnight because the federal district court has an electronic filing system, or the Federal Court of Appeals has an electronic filing system. He has until midnight tonight to file his supplemental brief.
But a supplemental brief, what is that? Just more, hey, I'm asking for more relief.
When the appeal was originally before the Fifth Circuit, it was briefed by the parties. When Reed's case went back, he sought supplemental briefing, perhaps to cover issues other than the timeliness. Now I haven't read I read the briefs originally 2 years ago. I haven't read them in a while. I don't really recall whether the timing issue was even argued at the Fifth Circuit. That's always been kind of the thing that's baffled me about their affirmance based on timing, because the judge in the district court didn't really address timeliness. Although, again, I think that, at least April of 2017, once because a rehearing is not, that ultimately they found that his request for rehearing stopped the clock. And he had until that was denied. But in this particular proceeding, and in Louisiana state courts, sometimes requesting rehearing or a new trial is to your advantage, and sometimes requesting a rehearing or a new trial doesn't stop the clock. You can do it, but your time is still going to run. And you have to be very careful, because I worked with, for example, an attorney who opposed an appeal because they requested a new trial in the trial court, but it was not timely. And then they didn't file their notice of appeal. It resulted in them filing a notice of appeal late. So we were arguing basically that their entire appeal was untimely, and they hadn't sought the court's permission to file an untimely appeal. This is a civil case. We also had another one years later where requesting a rehearing didn't stop the clock, but they didn't file their notice of appeal until after the rehearing had been denied, which was like 3 or 4 days late from when it was actually due. So supplemental briefing is maybe they're going to be more focused on the issues that remain to either challenge dismissal or to support dismissal. It'll be interesting to see what the supplemental brief is. And if it's more of the same things that they filed before in the U.S. Supreme Court, maybe they're going to try and, because I think they have like 8,000 words. They may be trying to put in the amici stuff about how DNA evidence can, exonerate people and save innocent people from wrongful conviction, et cetera, and ignoring the fact that that's not what we have with Reed's case. So, but yeah, and I'm sorry if that turned into a 45-minute answer. You know me so well. But
no worries.
It's something that Reed's attorneys felt the Fifth Circuit needed to determine whether the underlying federal civil rights claim was properly dismissed.
Got it. That makes sense.
All right. Okay. So anyway, so we're going to go back to the state court writ, the number 10. The opinion was issued by Judge McClure. And I was initially, I'm going to start off with a bit of an aside. I was initially actually somewhat perturbed with the Texas Court of Criminal Appeals because Judge Langley issued his findings of fact in November of 2021. And 2021 ended and Reed filed yet another writ. And then 2022, we went through all of 2022 and it ended and still nothing, no decision. And I was quite, aggravated and somewhat concerned because I thought, oh my gosh, are they really taking all this seriously? And so I was a little concerned that there might be a Adnan Syed type debacle. When I saw a 129-page opinion, I realized that they spent this time wisely by going through the entire record of Reed's direct appeal, trial, and every state post-conviction claim he's ever filed. And every bit of evidence that he's ever presented in support of those claims. So I was wrong to doubt that the Court of Criminal Appeals was taking the time that it needed to come to a fair and balanced decision. And that's what they did. And first off, I'll say they did not follow Judge Langley's findings of fact and conclusions of law. And they, in fact, found that in some points, Judge Langley wrongly adopted the state's finding of facts and conclusions of law, that he should have more carefully looked at those findings before adopting them. And I kind of agree because there were a couple of things that I found as well that were kind of wanting in the state's findings and then Judge Langley's adoption of them. But anyway, that's neither here nor there. It's just my opinion. The overview is that Reed filed his 9th subsequent -10 11.071 application in November 2019. He raised 4 claims: a Brady claim, a false testimony claim, an ineffective assistance of counsel, IAC claim, and a claim that he could prove his innocence both substantively under Elizondo and as a gateway for reaching other constitutional claims under Article 11.071, Section 5A2. We concluded that Reed's Brady, false testimony, and actual innocence claims 1, 2, and 4, satisfied the requirements of 11.071, Section 5. Accordingly, we remanded those claims to the habeas court for further development. And that was in Ex parte Reed, an unpublished decision dated November 15, 2019. The habeas court held an evidentiary hearing in July 2021, focusing mostly on Reed's most recent actual innocence claims. Reed called 19 witnesses at the hearing. The state called 29. At the -10 hearing, the habeas court admitted what it later described as numerous exhibits, including the entire record of Reed's trial and prior state habeas proceedings. On October 31st, 2021, the habeas court made recommended findings of fact and conclusions of law, which, if adopted, would have us deny relief on all of Reed's remanded claims. Now, one of the things I think is important to look at, and the TCCA looked at it, I'm going to go over the state and post-conviction DNA results one more time, because this plays a huge part in Reed's actual innocence claims. There's the vaginal swab from Stacy collected during the investigation, which the testing of that DNA did not exclude Reed from the sperm and epithelial fractions. Rectal swab from Stacy in a paper fold. Again, Reed could not be excluded from the sperm and epithelial fractions. Right breast swab from Stacy in a tube. Reed could not be excluded. Stain from victim's loo panties, sperm and epithelial fractions also could not exclude Reed. Additionally, previously obtained YSTR profile from the epithelial fraction was consistent with Reed's YSTR profile. Austin DNA, DPS DNA extract for item number 46, the back brace collected from Jimmy's truck in a tube. Reed could not be excluded as the contributor of the major component in the male DNA profile. Austin DPS DNA extract for number 16, blue pants. Those were the pants Stacy was wearing when her body was discovered in a tube. Reed could not be excluded as a contributor of the major component in the male DNA profile. And then finally, item number 24, a beer can found on the side of the road. Amber Heard of the Garland DPS, Allison Heard, my apologies, of the Garland DPS lab.
You're going to call me Johnny Depp next.
No, I did that, and I thought I changed it back to Allison. Allison Heard testified based on the most up-to-date manual interpretation guidelines that we have. I cannot make any conclusions as to who may have contributed DNA to this profile. So what this means is that the DNA mixture from 1998 and 2001 for that beer can is no longer in play. Because based on mixture interpretation, current mixture interpretation guidelines, you can't make any conclusions as to who contributed to the mixture.
Yeah, the beer cans used to be, I don't see it as much anymore, but the beer cans used to be part of the conspiracy theory, it seems like.
Correct.
That was the killer's beer cans.
Correct. Well, but the problem with that was that it made no sense because the mixture didn't exclude Salmela, Hall, and Stacy. It made no sense that they were standing at the side of the road, all three drinking from the same beer can.
Yeah, it was always one of the craziest theories.
There was never any explanation for how that, had it just been David Hall's DNA, or a mixture that didn't exclude David Hall, which is all it was. It wasn't really Ed Salmel's DNA or Stacy's DNA or Hall's DNA. It was they all possessed alleles that were found in the mixture on that beer can. So they couldn't be excluded as donors of alleles in the mixture of DNA. But again, now that beer can is no longer in play because no analyst can say who contributed to the mixture.
Right.
So now we'll go over the court's analysis of Reed's actual innocence claims, each of the claims that were remanded. The first claim they examine is the actual innocence claim. They held that even if all of Reed's post-trial evidence is taken into account, Reed still has not demonstrated that he's more likely than not innocent of Stacy's murder. That said, where Reed relies on evidence that could have been marshaled at trial, we will note that fact. In assessing a schlup claim, a court may consider how the timing of the submission bears on the probable reliability of that evidence. We leave for another day the question of what kinds of post-trial evidence should be considered in a Section 5A2 analysis. And the first component of Reed's actual innocence claim is the relationship evidence. They found that Reed's post-conviction case for a romantic relationship is not some ironclad thing in comparison, incapable of being undermined through vigorous cross-examination. We do not dispute that Reed would have been in a better position at trial if he had the 2021 witnesses at his disposal. However, better position at trial is a far cry from by a preponderance of the evidence no rational juror could have convicted. The fact that some evidence of a romantic relationship between Reed and Stacy was already before Reed's jury makes it that much harder for Reed to show on habeas that if only the jury knew about this other body of similar evidence, more likely than not, his trial would have ended differently. They went on to say that their opinion in the 03 habeas proceeding explains why, more likely than not, the jury would still have resolved this issue against Reed. The circumstantial evidence pointed powerfully toward the conclusion that Stacy was sexually assaulted. See Reed 271 Southwest 3rd at 748, 750. For instance, Stacy was found clothed only in a black bra and a pair of blue pants with a broken zipper, and her underwear was rent in the crotch and bunched around her hips. And from there, it takes no great leap in logic to conclude by a preponderance of the evidence that the reason Stacy had semen in her vagina is that her assailant left it there. Then they talk about the Jimmy killed Stacy evidence. To be sure, there has also been evidence adduced since the 03 proceeding that is broadly consistent with the healthy suspicion evidence that Jimmy killed Stacy. Among other things, there is evidence concerning Fennell's bank account, Detective Gannon's observation that police officers often sit on top of their buckled seatbelts. And I want to say that's bull. I've always found that to be bull because state law requires you to wear a seatbelt. How you ride in your patrol car is irrelevant to how you would ride in your personal vehicle.
Yeah, no, that's right. And that's all. Yeah, I always thought that was just extremely silly.
I also would argue that the bank account evidence, it's not unreasonable if you're told that your checkbooks are missing or you physically observe that your checkbook is missing from your vehicle, it's not an unreasonable reaction to go to your bank and either close your account and immediately open a new one in the same bank, or take your money out of your bank and go open a new account in some other bank. And we don't know. I mean, the evidence is not clear. They've never presented any evidence directly from the bank or whoever dealt with Jimmy at the bank that Jimmy actually took the money and kept it. That's what the paperwork they've presented suggests, but they haven't presented any evidence that he didn't just go open a new account with the same bank. So again, and from what I saw in the amount of money that he got from closing his account was not enough for him to flee past Austin.
Right.
I mean,
And
he might have
they
gotten as far as Austin.
they claim he did it right after the murder. Is that correct?
And yeah, and they haven't presented any evidence. They haven't, it was in the morning, but they haven't presented any evidence whether it was at 8:30 or 8 o'clock. And some people are saying 8 o'clock or 7 o'clock or 8 o'clock. The banks probably didn't open till 9.
Right.
I don't know what the bank hours were in 1996. Let's say, okay, maybe they opened at 8:30. But even then, the morning comprises up until 12 o'clock noon.
Right.
So he could have gone in at 11:45 and that would have still been the morning. So we don't have any evidence of the precise time in the morning. So allegations that he did this instead of looking for Stacy are unsupported by or uncorroborated. Their allegations are conclusory allegations, and they're coming from a nutter named David Fisher most of the time. So, take anything David Fisher says with a grain of salt. You can take what I say with a grain of salt. However, most of the time, I can back it up if it's based on trial record.
Right.
I can tell you who testified and what they testified to and where you can read their testimony for yourself. David Fisher doesn't do that. So anyway, so I dispute those two things, but the Court of Criminal Appeals is giving Reed the benefit of the doubt. Also, Gannon's opinion that it looked like a police officer had staged the crime scene. That was in his 2007 application. Curtis Davis's CNN interview, in which Curtis Davis said that Jimmy made statements inconsistent with his trial testimony, which was in the 2000 the 2008 writ and 2008 hearing on that writ. The court went on to say, but even taking this evidence into account, the loss of the beer can DNA evidence severely weakens the theory that Fennell killed Stacy. Hall's non-exclusion from the beer can was perhaps Reed's only evidence-based avenue of explaining how Fennell could have murdered Stacy, left his truck at the Bastrop High School by 5:23 a.m., and returned to Giddings in time for Carol to rouse him from his apartment. With Hall's DNA on a beer can near Stacy's body, one could at least imagine the possibility of Hall serving as Fennell's wheelman. Without that result, the evidence returns to a state where it is much harder to see logistically, pardon me, logistically, how Fennell could have murdered Stacy and made it back to Giddings so quickly. It might be possible to imagine ways in which Fennell could have accomplished this feat, but as mentioned, a showing of actual innocence calls for affirmative evidence. See Franklin, not imagination. It is certainly possible that as a matter of historical fact, Fennell really did have a deep-seated fear that Stacy was having an affair with a black man. There is a wide gulf between it is possible that X and it has been proven more likely than not that X. Even viewed holistically, Reed's evidence has not accomplished the latter. Even if it did, showing that Fennell suspected or feared that Stacy was sleeping with a black man is a far cry from showing that, more likely than not, he strangled Stacy to death. It would be a brick, maybe even an important brick, in the Fennell killed Stacy wall, but it would not by itself complete the wall. Other obstacles there would still be the ever-present logistical implausibility of Fennell murdering Stacy, leaving his truck at the Bastrop High School, and then returning to Giddings in a matter of hours. The jury heard from one witness, Tammy Hanneth, who hinted that Fennell was a jealous, possessive boyfriend who had possibly slashed Stacy's tires. This is from the 2003 writ. The fact that some evidence of Fennell's toxicity was already before the jury makes it much harder for Reed to show on habeas that if only the jury knew about this other body of similar evidence, more likely than not, his trial would have ended differently. And this is all the allegations about Fennell being violent, Fennell abusing Stacy, the arguments between Fennell and Stacy heard by Sappington, et cetera, et cetera.
Well, and I mean,
Which,
I think even more simply, like, if you just think about it in isolation, if Fennell wanted to kill Stacy, he wouldn't have done it this way. Like, there's 100 other different ways that he could have done it.
right.
It just doesn't make any sense. I mean, if you just close your eyes and you put away all the crap, it just doesn't make any sense that he would, the way that he did it, like this scenario, it just does not make any sense. I mean, it's silly. I mean, there's 100 other ways he would have done it that could have made more sense. I mean, if nothing else, like you said, he's a cop. He's going to at least be smart enough not to do it 30 miles away because something happens on the road. He has no reason. Why are you out 30 minutes from home at 3:00 in the morning? Like,
correct.
It's just illogical. I mean, it's just illogical. It doesn't make any sense that he would have done it but he wouldn't have done it in this fashion.
Correct. And, the thing to me as well that has always made it seem very convoluted is that the primary target in this situation would not necessarily have been Stacy. It would have been Reed.
Right.
And it would have been Reed who would have sustained an accident or been found shot to death somewhere.
Yeah, that's exactly
would have
right.
been shot by a police officer. I mean, the whole idea that they're going to frame and again, this is a conspiracy theory, and it supposedly started before Stacy's body was ever found, and all these officers were in on it. So why would they wait until April 4th, 1997 to even talk to Reed?
Yeah, exactly. Why wouldn't have they framed him the day after?
Why wouldn't they just leave the truck in the parking lot? Leave the truck in his mama's driveway, or his grandmama's driveway, or on the street in front of his grandmama's house.
Yeah, and that's the way. I mean, and that's the theme. I find the themes throughout all of these cases, and you see that in all of these where there is some new alternative suspect. If you just close your eyes, imagine the alternative suspect committing the murder the way that that person would have to do it. It just makes zero sense.
And, the other thing that the Court of Criminal Appeals did not bring up, which I think bears repeating here, is that, yes, there is conflicting evidence as to whether Fennell and Stacy had a peaceful, loving relationship or whether there was jealousy, possessiveness, and abuse. However, we also have allegations from Lucy E. and Carolyn R. that Reed was an abusive boyfriend. Lucy testified during the punishment phase that Reed abused her all the time.
Right.
That's why their relationship ended. And after their relationship ended, he broke into her mother's house and raped her in front of their 2 children.
Exactly. Well, yeah. I mean,
and beat her.
Well, again, it's the same thing. They always apply a different standard to the convicted versus the alternative suspect.
Right.
So again, do you take allegations that, okay, what man and what, 25-year-old man isn't jealous? Like, they all are. And then 2, let's just forget, Reed's, previous rape that he was arrested for, the subsequent attack, all the other ones in between. I mean, good night. I mean, it's just to completely forget about that, but then base everything on one witness that said, Stacy and Jimmy had a fight once.
Right. And I've said it before and I'll say it again, even if there was a relationship with Reed, if Stacy ended it and then ran into him and he sweet talked his way into that truck, she could have ended up raped and murdered because she had had the gall to end her relationship with Reed. Now, again, I don't believe there was a relationship, but Being in a relationship with Rodney Reed did not exempt a woman from being brutally raped and beaten, and in this case murdered. And maybe by the time he raped and murdered Stacy, he had gotten to the point where he was sick of being talked to by police. He was sick of facing consequences for his actions. And so if they can't tell anybody, the cops can't do anything to me. So maybe he had resolved to kill everybody from then on.
Right.
You know,
Well, and
I mean, it's my speculation, but I don't think it's unreasonable.
No. Well, and I get frustrated because it's, just it's bad enough that we don't talk about the victims nearly enough in these cases, the general public or the innocence fraud movement. But it just is extremely frustrating when innocent people and the victims constantly get slandered without any evidence, making her out to be that she cheated on her fiance. Fennell was not a good guy. He did some bad things years later. But again, to slander him as a murderer with no evidence is really unfair to him.
Correct. I totally agree. And especially in a case in which the DNA evidence linking Reed to this crime is so overwhelming. It's just there's no excuse for it. All right, so back to the findings or the analysis part. So anyway, Reed's efforts to prove that Stacy died hours before 3 a.m. on April 23rd, 1996, run into several significant headwinds. At the 10 hearing, Reed's own experts stated that the science underlying time of death determinations is the same today as it was in 1996. Reed has not otherwise shown, indeed does not even assert, that the scientific community's understanding of postmortem interval has meaningfully advanced or even changed since the time of trial. So under our actual innocence jurisprudence, the evidence Reed has marshaled on this point either cannot factor into the analysis for Elizondo purposes or carries less probative weight for Schlupp purposes. Over the last 2 decades, Reed has gone from seemingly having no qualms with Bayardo's time of death estimate. He didn't challenge that in his first writ or his direct appeal, to asserting that the lack of data made it impossible for someone to reliably determine Stacy's time of death, to asking this court to find that Stacy was alive as late as 5:30 a.m., to asking this court to find that Stacy died several hours before 3 o'clock a.m. Reed's inability or unwillingness to stick to a single consistent theory seriously undermines his assertion that more likely than not, the theory he is advancing in this proceeding is the correct one. In this regard, little has changed since 2008. Then as now, Reed has failed to advance a singular, cohesive theory of innocence. For argument's sake, we will set those inconsistencies aside and review this category of evidence on its own merit. Reed's evidence runs into yet a third headwind, this one arguably more fundamental than the others. It simply fails to persuade. At the -10 hearing, Doctors Baker and Davis both stressed that even under ideal circumstances, estimating time of death is an imprecise science, and qualified, experienced medical examiners could look at the same data and reach different conclusions about time of death. Reed's evidence on this score, therefore, fails to show that, as a matter of historical and scientific fact, Stacy died several hours before 3 o'clock a.m. on April 23rd, 1996. At most, it shows that a medical examiner could, within reason, conclude that she died hours before 3 o'clock a.m. As a result, Reed's evidence merely presents differing opinions that a jury could reject. And in the actual innocence context, that kind of evidence will not carry the day.
Right. Well, it's
Reed,
always hard in these It's always hard in these all cases, right? Because you can pretty
Mhm.
much get an expert to tell you what you want to hear. And so to the court's point, it's imprecise and it's not convincing, even if one expert does say she died at a different time.
Correct. And one of the things is that this isn't new. This is not the methods and the means are no different now than they were in 1996.
Right. Yeah, to
What
your point. Yeah.
what Reed's experts are doing is they're looking at different pieces and they're looking at different sources and they're coming to different opinions. But even their opinions are not uniform. Because there are some that say she died when we know she was alive and well with her mother. And Fennel wasn't there.
Right.
So and they're not supported by any corroborative evidence. For example, somebody seeing Fennel dumping the truck, somebody seeing Fennel dumping the body.
Right. Well, and to that point too, I think it's, again, Rodney Reed has no alibi. Nobody can account for his whereabouts.
Correct. All right. Reed's experts' opinion about Stacy's time of death are based entirely on rough visual estimates and secondhand descriptions of Stacy's rigidity, lividity, and decompositional state. It is difficult to place much stock in Reed's experts' pronouncements in these regards, i.e., about when Stacy must have died or when she cannot possibly have died, when the data underlying those pronouncements are so subjective and inexact. That difficulty is only exaggerated by Reed's experts' refusal to account for supposedly non-forensic considerations, like the attire Stacy's body was found in and her work schedule. It may be, as Baker stated, that it is ultimately the fact finder's job to decide the relevance of non-forensic considerations such as these. But the same could be said of everything Reed's experts testified to, and to the extent that Reed's experts were reaching conclusions that were in tension with the non-forensic circumstantial evidence, it is not unreasonable to expect Reed's experts to account for that tension, and they did not. The October 2007 incident, which was Fennel's rape of Connie L. in Georgetown, is compelling evidence that Fennel once engaged in violent and or oppressive acts. The other instances, and these are allegations that came about during the investigation of Connie's attack, that Fennel, I think there was one other sexual assault, and then there were some inappropriate statements and behaviors that didn't progress to sexual assault, that witnesses came forward. The other instances obviously carry less weight in the analysis. Reed did not call any of Fennel's accusers to testify at the 10 hearing. Fennel's extraneous conduct is a brick in the Fennel killed Stacy wall. The problem for Reed is that if we accept the premise that extraneous conduct can shed light on the identity of Stacy's killer, there is no principled reason to treat Fennel's extraneous conduct as relevant to that inquiry, but Reed's extraneous conduct as some kind of third rail. And once that threshold is crossed, we find that Reed's extraneous conduct points far more forcefully toward the conclusion that Reed killed Stacy. As mentioned at the punishment phase of Reed's trial, the state introduced evidence that Reed sexually assaulted at least 5 women before Stacy's murder: Connie Y., Minor A.W., Lucy E., Vivian H., Carolyn R., and attempted to sexually assault another after, Linda S. If credited, this evidence strongly suggests that, despite Reed's claim of a consensual secret rendezvous between himself and Stacy, Reed in fact sexually assaulted Stacy. And from there, it takes no great leap in logic to conclude that if Reed sexually assaulted Stacy on the morning of April 23rd, 1996, by a preponderance of the evidence, he is most likely the person who strangled her as well. There's little, if any, evidence to support the theory that while Reed may have sexually assaulted Stacy, someone else killed her. Our analysis does not treat Reed's extraneous conduct as guilt phase evidence, nor indeed as evidence that Reed is guilty of anything, in the sense that a jury might declare someone guilty of a crime at the conclusion of a criminal trial. A court reviewing an actual innocence claim has no occasion to decide whether the claimant is guilty of anything, including the crime of conviction. But it does have an occasion and the authority to scrutinize the claimant's assertion that he is innocent. Just so, our analysis treats Reed's extraneous conduct not as some additional evidence that Reed is guilty, but as evidence undermining his claim of innocence. And this is like, I bolded it, this is like the most important and the best statement that the Court of Criminal Appeals could have made in its analysis. And thank you, Judge McClure, because this is the elephant in the room. If Fennell's extraneous conduct is relevant, so is Reed's.
Exactly. That's
And
exactly.
Reed's extraneous conduct undermines his actual innocence claims.
Yep. They always want it both ways.
Mm-hmm. And they, at the hearings, Reed's attorneys tried to block. They tried to block the post-conviction DNA testing results, and they tried to block extraneous offense evidence. They weren't successful, but it was curtailed by the state to a degree. And this is because the Court of Criminal Appeals went on to say, we've never held that the state is prohibited in a post-conviction context from adducing evidence undermining an applicant's showing of actual innocence. See Boozley, which is a U.S. Supreme Court case, noting that in seeking to rebut a claim of actual innocence, the government is not limited to the existing record. And this is something also that the court of public opinion often doesn't acknowledge or recognize. They try to put the prosecution into a box and say, you can only use your trial record. That's it. You can't bring anything else in. But we can do whatever we want.
Right, exactly.
And we can bring rumors, and we can bring triple hearsay, and we can do what we want, but the prosecution is limited. And I've seen in my discussions with the West Memphis 3 case, I often had supporters telling me, well, no, that wasn't at trial, so you can't talk about that.
Right.
And it's like, BS, I can't. So just as you could talk about, stuff that people did after trial.
Right.
And then they went on to say, we are also aware that none of Reed's extraneous conduct has yet resulted in a criminal conviction. Indeed, when Reed was tried for sexually assaulting Connie Y, he was acquitted. But here again, this is not a criminal proceeding that will decide whether Reed is guilty or not guilty of capital murder or anything else. This is a post-conviction proceeding that will decide, among other things, whether Reed has adequately demonstrated his innocence. As we explained when it came to Fennell's extraneous conduct, the fact that these extraneous instances did not culminate in criminal convictions does not necessarily make them irrelevant to the innocence inquiry. It just means that we must temper whatever probative weight we might otherwise have assigned to them. The bottom line is that even viewed with appropriate skepticism, the evidence of Reed's extraneous conduct still casts a considerable pall over his claims of innocence. And then they went on to talk about other post-conviction evidence that Reed has brought forth, including procedural criticisms of the investigators and handling of the crime scene, forensic opinion testimony, and allegations of false, misleading testimony. We've taken this evidence into careful consideration. It does not get Reed across the actual innocence finish line. None of this information affirmatively demonstrates Reed's innocence. That is, it neither affirmatively shows that Reed did not kill Stacy, nor affirmatively shows that someone else did. At best, this category of evidence weakens the state's case in chief, but that is not the point of an actual innocence claim. See Franklin. When a defendant seeks actual innocence relief after he's been validly convicted and sentenced, it is fair to place on him the burden of proving his innocence,
Right.
not just raising doubts about his guilt.
Yeah, that makes a lot of sense. That's
And
really
that
well
quotes
said.
Herrera versus Collins.
Yep.
And, you know, I mean, I'm sure you've seen it. People say there's reasonable doubt. There's reasonable doubt. You know, look at any Reddit category and in any pro Reed or any pro Glossop or any pro West Memphis 3, you'll see there's reasonable doubt. I have reasonable doubt.
Right.
And the time for reasonable doubt is at trial. Once you're
Right.
convicted, that's over. And you may perceive something as reasonable doubt, and it may be sufficient that had you been on the original jury, you would not have convicted. But often what I find is the things that people perceive to be reasonable doubt are presented to them in isolation
Exactly.
and presented to them either without any inculpatory information or with all inculpatory information deemed not reliable, not credible, or otherwise refuted, even though it hasn't been. And that's basically that's the tactic that the Innocence Project is using. They're pretending that this 129-page opinion doesn't exist. And I mean, Jane Pucher in her statement said prosecutorial misconduct, you know, prosecutors are being allowed to cheat and get away with it. And this is hurting an innocent man. And we're going to bring Rodney Reed home. And it's like, bullshit. Read the 129-page opinion. I did. You know?
Right.
And look at what, you know, why they're saying, why they're doing what they're doing. And it makes perfect sense and it's perfectly reasonable. I mean, you know, any pro Reed people who happen to listen to this, please tell me what's not reasonable about this.
Yeah.
And again, the court did not take Judge Langley's credibility and reliability findings. They basically looked at everything and made their own. And if you'll notice, what I'm talking about in this analysis doesn't really talk about witness credibility or witness reliability, because in the end, this is not sufficient to prove Rodney Reed actually innocent.
Right.
And that's the basis for their decision. So, and then, you know, that was a quote from Herrera versus Collins. They also quote from Schlupp saying, distinguishing the standard to be applied in procedural actual innocence claims from the standard that governs review of claims of insufficient evidence. So, you know, again, they're not looking at this as the sufficiency of the evidence question. That is a direct appeal. That's done. They found the evidence sufficient. Now the burden's on Rodney Reed to prove that he's actual innocence with affirmative evidence, either proving his own innocence or affirmatively proving someone else guilty. And given the overwhelming DNA evidence, that is a task that he simply cannot prevail.
Yeah, well, it goes back to what you said at the very beginning. It's just funny because usually the Innocence Project is if you don't have DNA everywhere, then the convicted must be guilty. And it's just funny that his DNA is everywhere, but suddenly in this case, uniquely, it actually, you know, it's not enough to prove his guilt. It's to your point, you have to take everything they say in isolation. None of it holds together into a single system.
Yeah. All right. So they go on to talk about some of the other post-conviction evidence. Reed's ongoing efforts to dismantle the state's theory that Stacy was anally penetrated before she died. Even if Reed could definitively prove that Stacy was not anally penetrated before she died, that would not detract from the evidence suggesting that Reed forced Stacy to have vaginal intercourse. Any deficiency in the evidence suggesting anal intercourse does not necessarily support Reed's theory that he and Stacy engaged in consensual vaginal intercourse. Compelling independent circumstantial evidence showed that Reed forced Stacy to have vaginal intercourse. And I guess I should have given a warning, and I may record and add a little warning to the beginning. Unfortunately, this involves rape and murder, and where I usually try to be more circumspect about the language and the concepts, I think in this case it's important to confront them head on and not try to use euphemisms or to just go with it. So I will add a warning at the beginning that this one, or maybe a warning in the comments that, this does deal with rape and murder, and it's probably going to be a little a little clinical for some people's tastes. And I don't mean it as any disrespect to Stacy. Then they go on to say Reed's efforts to show that Karen Blakely's bruised dating testimony was unsupported, or that Megan Clement was not qualified to testify about sperm longevity. None of these efforts affirmatively demonstrates that Reed is innocent. At best, they show that state's experts gave unsupported or unqualified testimony. But this is not the kind of due process violation this court's actual innocence jurisprudence is designed to address. And that refers to a case called Franklin, a Texas case. Our holding in Elizondo was meant to act as a mechanism for freeing the innocents, not to quibble about whether somebody meant is or not. That is not the situation we face here. It is not as though, but for some otherwise intact facet of the state's case, Reed would be able to establish his innocence to the necessary level of confidence. Given its questionable credibility and weight, Reed's affirmative evidence of innocence, i.e. the consensual relationship and fentanyl killed Stacy evidence, does not amount to a more likely than not showing that Reed is factually innocent of Stacy's murder. That being the case, the evidence in this phase does not get Reed to where he needs to go, an affirmative, fact and conduct-based showing of innocence. See Ex parte Fournier, another Texas case, emphasizing Elizondo's fact and conduct-centric notions of actual innocence. So the court finally, in their finding, they found that taking all the foregoing phases of evidence into account, Reed has not shown by a preponderance of the evidence that no rational jury would have convicted him in light of his post-trial evidence of innocence. His lay witnesses have given accounts that are questionable at best when viewed in isolation and disharmonious when viewed holistically. His scientific and forensic experts have relied and continue to rely on science that has been available since the time of Reed's trial, and even looking past the prior availability issue, Reed's scientific and forensic evidence does not affirmatively show that Reed is innocent. It reflects differing opinions, not a scientific consensus pointing toward Reed's innocence. Finally, to whatever extent Fennell's extraneous conduct shifts suspicion away from Reed and toward Fennell, Reed's extraneous conduct added to that evidentiary mix shifts the suspicion back to Reed and then some. Reed's history of sexual assault seriously discredits his assertion, of which he is trying to persuade this court, that he and Stacy had consensual sex. These observations suffice to dispose of Reed's procedural Section 5A2 based innocence claim, as well as his substantive Elizondo based innocence claim. Because it does not warrant relief under either rubric, claim 4 is denied. And then they go into the Brady claims regarding witnesses that they claim were suppressed by the state. That's claim one. And so Richard Derleth, who testified that HEB employees told him they had an alert system in place to warn Stacy when fennel was coming to the store. Because Reed has not come forward with sufficient credible evidence to show that, more likely than not, the events described in Derleth's affidavit actually happened, he has not met his burden to show that the state suppressed evidence of a Jimmy Fennell alert system at the Bastrop HEB. Therefore, this Brady sub-allegation fails. See Brogdon versus Blackburn, which is a Fifth Circuit case from 1986, which basically says the prosecution has no duty to turn over evidence that does not exist. Based on this resolution of the Derleth sub-allegation, we do not need to decide, as the habeas court did, whether Derleth was part of the state for Brady purposes, whether the state would have been excused from divulging this information because it was hearsay, whether Derleth's information was material, or whether this sub-allegation should be denied on laches grounds. Charles Fletcher, who talked about Fennell's cold behavior at Stacy's funeral. Yet again, they found that because Reed has not shown that Fennell's cold behavior at Stacy's funeral was material evidence, evidence whose absence at trial should undermine our confidence in Reed's conviction, this Brady sub-allegation fails. Based on this resolution, we do not need to decide, as the habeas court did, whether Fletcher's allegation about Jimmy's behavior at the funeral was credible or accurate, whether it would have been favorable to the defense, whether Fletcher was part of the state for Brady purposes, or whether laches should bar relief on this sub-allegation. And also, it's important to note that the TCCA pointed out that one of the exhibits was a report by David Board from a witness who said that Fennell wasn't acting appropriately at Stacy's funeral. And Reed has never said he did not have that report or did not have access to that witness or the testimony. So, this is not new evidence. It's not a new concept that could not have been presented at trial, which is another reason it fails.
Exactly.
Ultimately.
Yeah.
Charles Fletcher, Fennell's racist comment. Because Reed has not come forward with sufficient credible evidence to show that, more likely than not, Fennell told Fletcher that he thought Stacy was fucking an N-word, Reed has not met his burden to show that the state suppressed evidence of this utterance. Therefore, this Brady sub-allegation fails, and it refers to Brogdon again. The prosecution has no duty to turn over evidence that does not exist. Based on this resolution, it's also not necessary for the court to decide whether the information was favorable to Reed, whether Fletcher was part of the state, whether the information was material, or whether laches should bar relief of the sub-allegation, or as between Fletcher and Fennell, who was more credible witness. Jim Clampett. Because Reed has not come forward with enough credible evidence to show that, more likely than not, the events described in Clampett's affidavit, and that was that Fennell told Stacy's dead body that she got what she deserved, that the events described in his affidavit and testimony actually happened. Reed has not been his burden to show that the state suppressed evidence, and the prosecution has no duty to turn over evidence that does not exist. And they also don't have to decide whether he was part of the state, whether his information was material, whether laches should bar relief, or whether who was more credible between Clampett and Fennell. And, just to remind people, Clampett was either suspended or fired from his job for falsely testifying in uniform at a friend's DWI hearing or trial.
Mm.
So, he had a very serious credibility issue. The finding. Oh, were you going to say something?
Oh no, I was going to say, yeah. I mean, definitely doesn't sound like the most honest guy.
No. So the finding was, having rejected each of Reed's sub-allegations, we conclude that his Brady claims lack merit. To be clear, apart from Fletcher's allegation regarding Fennell's cold behavior at Stacy's funeral, we do not resolve Reed's Brady claim based on materiality. Instead, we find that the allegedly non-disclosed evidence did not come into being until well after Reed's trial. To the extent Reed's witnesses claim otherwise, we do not credit their accounts. Because Reed has failed to establish that this evidence was suppressed before or during his trial, it is unnecessary for us to conduct a materiality analysis.
When you see this,
and
you see this in a lot of these cases, right? Where, I think the Adnan Syed case was one of the more famous ones where, years later, somebody comes and has, magically has some new testimony or saw the convicted. It's always years later. It's like, if you had all this, you should have come to the trial. Why were you quiet all these years? It just doesn't make a logical sense.
And and this is true with the HEB employees, and we'll probably get into it a little bit more with the 11 writ. Jimmy Brown and Lydia Clay Jackson have each been interviewed by State versus Reed, by 2020, by CNN, by another production company that produced a Dying for Love episode on ID. And they have both said they interviewed HEB employees who said Rodney Reed was telling the truth. There was a relationship, who confirmed a relationship. So, they say, Lydia Clay Jackson says these employees refused to testify. But Reed never produced
an easy cop-out.
Lydia Clay Jackson to say whether she talked to Hugan, whether she talked to Cardenas, whether she talked to Coronado, et cetera, et cetera, et cetera. So, and she's never identified who any of these employees were.
Right.
So, and that's one of the reasons I think that the IAC claim raised here was not remanded, because Reed did not present it in a way that warranted further development. So, and then finally,
I think, again, I just think if it's simple, again, they know that she was murdered. She obviously, everything I've read, she was well thought of. Maybe they didn't all know her. They probably liked her. And just, hey, my coworker was brutally murdered. Oh, wait, maybe her secret boyfriend might be a suspect. Like, you would think, if they all knew about this affair and they had this elaborate system to hide, not one of them would come forward and call the police and say, hey, she's having an affair with this guy. You might look at him as a suspect. It's illogical.
And take it a little further. You have Alicia Slater, who says Stacy told her she wasn't excited to get married, and was having the secret affair. But Alicia Slater doesn't think that's important when Stacy's murdered. And she's always suspected Jimmy Fennell, but she doesn't think it's important. And even if you won't go to the police because you're afraid of the police because of Fennell's police connection, once Reed is arrested and once Reed is on trial for capital murder, why would you not go to Reed's investigators and multiple?
Exactly.
A lot of people did. And why wouldn't you go to Reed's attorneys?
Right. It's just like the Asia McClain and the Hayman Lee case. Why didn't you speak up during the trial or go tell the attorneys that, hey, and even, and again, I still think too, Rodney Reed is sophisticated when it comes to the justice system. He has been on trial before this and he was acquitted. He has gotten in trouble with the law. So he is sophisticated enough to say, why didn't he raise his hand and say, hey guys, I just want you to know we're having an affair. You might find something. You might find my fingerprint in her truck. I just want you to
Yeah.
know I didn't do it, but I just want you to know I have been arrested before. Like, it's
And
illogical for
well,
him to raise his hand and
yeah.
say,
And you've got HEB employees who say they observe signs of abuse. They're the HEB employees who say they had this warning system. But when she's murdered, they don't go forward and talk
yeah,
about how
none
her
of them go to the
boyfriend abuses
police.
her.
Right. None of them go to the police then. Yeah,
And
it just
and
doesn't make sense.
and then finally the final one that makes the least amount of sense is that um Rodney Reed and his cousin claim that Jimmy threatened Reed, but Reed doesn't tell his attorneys about it. Because
Exactly.
that would have been question number one on cross-examination of Jimmy Fennell. I
Yep.
mean, that's just,
Well, and you've made this point earlier, and in all of these situations, like my wife and I joke about it because it's always strange. The jilted spouse or lover, 99% of the time, especially if it's a man, they go after the other guy. They don't
mhm,
usually go after their girlfriend. If you hear your girlfriend's cheating on you, 99.9% of the time, they go after the other guy
right.
because
Or
it's
they
kind of a
go after
guy
them both
thing.
when they're together.
Yeah, it's who's the bigger alpha. It's not a, hey,
Mhm,
I'm gonna go, I'm not saying they don't yell at the girlfriend, but like you're always gonna go take it up with the other guy. That's just
yeah.
it's your honor. So the fact that he would just not do anything, this grand conspiracy to kill Stacy, but then doesn't bother framing Reed, it's ridiculous.
Mhm. All right, so now we're on to claim number one, which was that Fennell's testimony at trial was false. Um, at trial, Fennell testified that he did not kill Stacy. Proving this testimony factually false requires Reed to show that, more likely than not, and as a matter of historical fact, Fennell did kill Stacy. In essence, this is another iteration of the theory that Fennell killed Stacy. As we explained in analyzing Reed's actual innocence claims, Reed has failed to prove that theory by a preponderance of the evidence. As a result, Reed has failed to show to the requisite level of confidence that Fennell testified falsely. This sub-allegation fails. At trial, Fennell was asked whether prior to any of this happening, presumably Stacy being killed and Reed being accused of murdering her, he ever knew a person named Rodney Reed. Fennell answered, no, sir. Proving this testimony factually false requires Reed to show that, more likely than not, and as a matter of historical fact, Fennell did know who Reed was before Stacy was killed. The theory that Reed advances at this juncture is that Fennell knew Miss Stites was having an affair with a black man. As we explained in analyzing Reed's actual innocence claims, Reed has failed to make this showing by a preponderance of the evidence. See Super page 97. As a result, this sub-allegation fails. The biggest impediment to the Fennell killed Stacy theory was not Fennell's self-serving assertion that he was close-knit and open with Stacy. It was the lack of any forensic evidence connecting Fennell to Stacy's murder, coupled with Ranger Wardlow's testimony that the Fennell killed Stacy theory was logistically not possible. Disproving Fennell's testimony about how happy he and Stacy would not make those impediments go away. Granted, giving the jury even more reason to doubt Fennell's testimony about his and Stacy's relationship could only have helped Reed's case at trial. But the fact that Reed already put evidence of this nature in front of the jury and was convicted anyway makes it much harder for him to show materiality on habeas. Having rejected each of Reed's sub-allegations, we conclude that his false testimony claim lacks merit. Claim 2 is denied.
Well, and I'm thinking about it again as you were talking. Again, you have to have a consistent theory that puts all the pieces together. So if you think about this guy, Jimmy Fennell, he's a hothead, such a hothead that he actually killed his fiance. for having an affair.
Mm-hmm.
But he never confronted her about it before, never told anyone, never made a scene, never said, "Hey, I keep
Mm-hmm.
hearing that you're it just doesn't make any sense that on one hand, he's gonna kill her, but then he's never even gonna bring it
Yeah.
up. He's
And
never gonna say anything. He's never gonna confront her. It's illogical.
yeah, and again, this goes back to the fact that all these witnesses who came forward 20 years later failed to bring any of this to the police attention. I mean, had even half of them brought some of this to the police attention, the allegations of abuse,
Right.
that would have given police probable cause to search the apartment. It might have given
Exactly.
police the gumption to more strenuously question Fennell's friends like Nathan Lapham, Curtis Davis, David Hall. Not that they would have gotten anywhere because Fennell didn't do it, but again, this information would have been what they needed at a time when they saw Fennell as the prime suspect.
Yeah,
But they
that's
didn't have
exactly
it
right.
because it wasn't given to them because these witnesses, quote, didn't know it was important, unquote, which is the most
Right.
ridiculous excuse I've ever heard for not coming forward at the time of a murder investigation.
Yeah, it doesn't. Well, I mean, again, the logical consistency. So let's say hypothetically, you participate in this complex early warning system at work for one of your colleagues. Like you care enough about her to participate in her early warning system to hide when her boyfriend comes in the store. So you take your time to do that, but
Mm-hmm.
you don't bother letting the police know when she's murdered. Again, it's just completely illogical.
Yeah, yeah. That is one of the things and it's one of the reasons that Reed's failed.
Yeah,
And I think because the witnesses that are coming forward are getting way too creative,
right.
and the more time that passes, the less credible they become.
Right. And do you think there's I mean, I know a lot of them, they like the attention. They might get a free trip out of it. They might think they get to go on TV. But do you think it's beyond the pale? Do you think the Innocence Project ever just gives people like direct compensation for basically making up, doing these types of things to keep these cases
It
in the limelight?
it would not surprise me. And I think that also we have to remember that a witness may contact the Innocence Project with something fairly innocuous, but then investigators from the Innocence Project will say, well, we can prove he's innocent. We just need your help.
Right.
And I would not be surprised if a lot of these witnesses were asked leading questions that provided more detail to their statements and they just went along with it.
Right.
And then they doubled down and stuck with it because they felt like they had to.
Right.
Um, and it may be, there may also be a component of opposing the death penalty.
Right.
I think that sometimes they get involved and they align themselves with the convicted person's family and advocates, and then they become invested in proving the convicted person is innocent. And so then they will go even farther by saying, "Oh, wait, I know this," So, I think there are a lot of layers and a lot of potential um, issues that come into play. I don't think it's any one size fits all. Alicia Slater, I think she aligned herself with Reed and Reed's family. And so then she decided she was going to help by saying, "Oh, I had this conversation with Stacy and she told me she was sleeping with a black guy named Rodney and she didn't want to get married." And, "Oh, well, I just didn't come forward because, I didn't want any trouble for my family because I knew he was a cop in the next town over.
Yeah, it doesn't. It doesn't
Yeah.
make any sense.
No. And in her Dr. Phil interview, what she displayed is something a behavioral analyst in the Jodi Arias case would have referred to as duper's delight. Because when she made these statements, she had this big old smile on her face and this playful voice, like it was a game and like she was getting one over on somebody.
Right.
So, and I wish that the hearings before Judge Langley, I wish he had allowed them to be videoed and broadcast, because I would have liked to have seen these witnesses. I mean, I would have loved to see Arthur Snow melt down at the beginning of his cross-examination and suddenly invoke his Fifth Amendment rights, and then have to be taken off the stand, and probably had to come to Jesus with Reed's attorneys by saying, if you do this and they can't cross-examine you, all your testimony goes out the window. And so then he had a cooling off period and came back and decided to be cross-examined. But he didn't want to cooperate with cross-examination. So I would have loved to see that. But it wasn't.
And what was the background of that? Why did is that because he incriminated himself? Is that why he was so leery of cross?
I think I personally think that he wanted to get up, do direct testimony, and then say, see ya, and not face the potential of perjury or being caught in lies. Because I think he knew these DAs were not going to be like, no questions. Thank you, Mr. Snow. Be on your way. He knew they were going to tear him a new asshole. And so he was belligerent and he invoked his fifth. I read the transcript a while back, but I'm going to probably read it again very shortly, because it was kind of amusing. And I can imagine, like I said, let's take a recess, and Andrew McCrae saying, you motherfucker, if you do this and you stick to this, your testimony goes away. Because if you won't submit to cross-examination, the side that wants to cross-examine you and has a right to do so can say, Judge, he won't be cross-examined. We want you to strike his testimony. And they would have been within their rights to do that, because he's not cooperating with the process.
Right.
So, all right. So, conclusion. In sum, the court found that Reed had failed to make an affirmative, persuasive showing that, likelier than not, he is innocent of Stacey Stites' murder. As a result, both his Elizondo-based actual innocence claim and his procedural Section 582 Schlupp-based actual innocence claim do not warrant relief. Accordingly, Claim 4 is denied. In addition, Reed has failed to show that the state withheld material defense favorable evidence in the state's possession at the time of Reed's capital murder trial. Therefore, Claim 1 is denied. Finally, Reed has failed to show that the state presented material false testimony at his capital murder trial. Claim 2 is denied. And I think I said Claim 2 was Claim 1. The false testimony was Claim 2. And what they did is it's similar to a direct appeal. They look at the actual innocence claim first, because if they find in favor on the actual innocence claim, they don't have to do anything else. He gets relief. He's done.
That makes sense.
So they look at the actual innocence claim, and on a direct appeal, if there's an insufficiency of the evidence claim, even if it's the last point of error raised, they'll look at it first. And then if it's denied or it's overruled, they'll look at all the other claims. So, as mentioned, Claim 3 is an IAC claim. When he filed his application, Reed did not demonstrate that claim 3 met the Section 5A1 exception to the bar on subsequent writ claims. If he had, we would have remanded that claim for further development, along with Reed's Brady, false testimony, and actual innocence claims. Accordingly, for claim 3 to warrant further reconsideration, Reed would have had to show that it satisfies a different Section 5 exception. That leaves Section 5A2 and 5A3. Reed has offered no evidence or argument in satisfaction of Section 5A3. And because we've concluded that Reed has not shown by a preponderance of the evidence that but for a violation of the United States Constitution, no rational juror could have found him guilty beyond a reasonable doubt, we necessarily find that Claim 3 does not surmount the Section 5A2 bar. Accordingly, Claim 3 is dismissed as an abuse of the writ under Section 5. Based on the foregoing, Reed's 9th subsequent -10 11.071 application is denied in part and dismissed in part. And then they go on the same day they issued the opinion or order in the -11 writ. That was also per curiam. Judge Walker dissented. Judge Newell did not participate. However, again, Judge Walker did not produce a dissenting opinion. If he does down the road, or it becomes available down the road, I will, of course, update. And the next time we talk about Rodney Reed, we will talk about the dissenting opinions and the reasons, Judge Walker's reasons for dissenting.
Yeah, it'd be interesting. I'd be curious to know what his rationale was.
In December 2021, Reed filed his 10th subsequent -11 11.071 application, the subject of this order. In it, Reed raises 3 claims. His claim 1 is a Brady claim, and it's based on letters provided during preparation for the July 2021 hearings that provided information to the defense out of an abundance of caution, that the AG provided to the defense out of abundance of caution. And the letter even says, we are not vouching for the credibility of any of these things. We're just providing it to you in an abundance of caution. So I'm going to summarize the analysis of each of the claims and what the claims were, so that we can see. But my prediction about this writ came true. More on that in a bit. Okay, the first thing they talked about was Susan Hugan, who testified to an alleged relationship between Stacy and Rodney Reed. So they begin with Reed's contention that A, Susan Hugan's -10 hearing testimony contained Brady evidence. They concluded the information that Hugan allegedly conveyed to Paul Alexander was immaterial. Hugan testified that she told Alexander that Stacy had introduced her to Reed as her friend, but Reed's jury already heard from one witness, Julia Estes, who said that she had seen Reed and Stacy socializing inside the Bastrop HEB. And another witness, Iris Lindley, testified that a woman who looked like Stacy had come by the Reed house asking for Rodney, kind of like of how a girlfriend looks for a boyfriend. To the level of confidence associated with reasonable probability, adding yet another dimension to this defensive theme is unlikely to have produced a different outcome. I would also point out that Hugan, in her statement provided to Reed, was not sure that the person she provided this information to was Paul Alexander. It was only when she testified that she became sure that it was Paul Alexander, who was now deceased. So that's
well, and again, it's illogical that if, Stacy was so afraid and they had this early warning system at the HEB. Like, let's assume that's true. She's just going to parade in public with Reed at the HEB. I mean, again, none of it makes any sense that, she would just, gladly be seen in public with him if she's this afraid of her fiance. Just none of it makes any sense.
But, apparently, according to Rodney Reed, they only saw each other at places where he thought it was safe, like the HEB where she worked, where he showed up apparently at will, the Bastrop Dairy Queen, and the Bastrop Walmart.
Right.
Okay.
Yeah, very highly public places. Yeah, it doesn't make any sense.
Yeah, and I don't want to digress on how stupid that claim is.
No, fair enough.
Susan Hugan also testified regarding bruises. She testified she saw hand-shaped bruises on Stacy's wrists, the implication evidently being that Stacy's fiance, Jimmy Fennell, was abusing her. Here again, however, Hugan did not say that she divulged this information to Alexander. Even if she had, and even if this disclosure led to Hugan testifying at trial that she'd seen hand-shaped bruises on Stacy's wrist, it's doubtful that Reed's jury would have believed Hugan in this regard. Stacy's autopsy did not reveal hand-shaped bruises on her arms or wrists, and we are aware of no other trial witnesses who could have corroborated Hugan's assertion in this regard. Further, hand-shaped bruises would not have alleviated the logistic implausibility of Fennell murdering Stacy, dumping her body in Bastrop, and getting back to Giddings without the use of his truck in time for Stacy's mother to rouse him from his apartment. To the level of confidence associated with reasonable probability, Hugan's information would not have cast the trial in a different light and does not undermine our confidence in the jury's verdict. And that cites Kyle's, which is a case out of New Orleans, which I maybe one day will profile because I actually have a 6 degrees of separation relationship with the victim. Then they go on to examine Ron Haas / Andrew Cardenas. They turn to Reed's contention that B and C, Ron Haas and Andrew Cardenas information, was Brady evidence. Here again, they conclude that this information was immaterial. The interview summaries collectively show that at the time of trial, the state ran Ron Haas's information to the ground. Haas himself attributed the rumor to Andrew Cardenas, so the state spoke with Cardenas. Cardenas denied ever seeing Reed and Stacy together, but he acknowledged there were lots of rumors floating around HEB. He directed the state to Jose Coronado, and the trail fizzled out there. Coronado never told anyone that Rodney Reed came into HEB and visited with Stacy. Likewise, he never saw Reed come into the store and take her out to lunch. According to Coronado, Stacy was excited about her upcoming marriage to Jimmy Fennell and did not talk about any other men or relationships. All of the witness statements in question were built on rumor and hearsay, and when investigated, they ultimately led nowhere. Further at trial, Julia Estes testified that she saw Reed and Stacy socializing at the Bastrop HEB. The fact that the jury heard this evidence and convicted Reed anyway makes it that much harder for Reed to show that Ron Haas, Andrew Cardenas information would have made a material difference at trial. And then Ted Weems, Reed's contention that Ted Weems' information was Brady evidence. Here, Reed has not shown that the factual basis for this claim could not have been ascertained sooner. See Article 11.071, Section 5A1. Reed attached Brent Sappington's affidavit to his 10 application. At the 10 hearing, Sappington stated in response to habeas counsel's questioning that his father Bill had reached out to Ted Weems in 1996. Reed has not explained why, having obviously spoken with Brent Sappington before he filed his -10 application, he could not have ascertained this information before November 2019. In sum, even considered in its totality, the bulk of the information that Reed characterizes as Brady evidence cannot be said to be material. Given its limited probativity, the fact that much of it was based on hearsay and or rumor, and its overlap with evidence that the jury already heard at trial, there is not a reasonable probability that its pretrial disclosure would have led to a different outcome at trial. Because Reed has not made a prima facie showing that he suffered a Brady violation, and because with reasonable diligence, at least some of this information could have been marshaled in the 10 application, Claim 1 is dismissed as an abuse of the writ under Article 1171, Section 5. Then he goes on to raise false testimony claims. He alleges Paul Alexander testified falsely. Reed has failed to make a prima facie showing that the alleged false testimony, i.e. that Alexander played only a minor role in the Stites murder investigation, was material. The extent of Alexander's role in the murder investigation was a trivial point in the context of Reed's trial, mentioned once in passing during Alexander's testimony and never brought up again. Beyond a reasonable doubt, this aspect of Alexander's testimony did not contribute to the jury's verdict. And also, again, you can't say Paul Alexander testified falsely if Susan Hugan is unclear or unsure as to whether she even talked to Paul Alexander. So I think, again, the Court of Criminal Appeals didn't go at it from that angle, but I think that that's an important distinction. Then Reed contended that the state gave the jury a false or misleading impression when it cross-examined defense witnesses Julia Estes and Iris Lindley. Reed has pointed to no specific testimony from any witness that actually left the jury with a false impression, and that refers to Ukuwachu, a Texas case. Reed asserts that the state's impeachment efforts were improper, but this court has previously declined to sustain a false evidence claim based solely on an allegation of misleading prosecutorial questioning absent some identifiable testimony that was problematic. As a result, Reed has not made a prima facie showing that a witness testified falsely. The same reasoning applies to Reed's contention that the state's closing argument falsely asserted that Reed and Stacy were not acquainted. And then Reed alleges that Andrew Cardenas testified falsely or misleadingly when he said he never personally saw Reed and Stacy socializing at HEB. Here, again, Reed has not made a prima facie showing that Cardenas testified falsely or misleadingly. Cardenas was asked a question about his personal knowledge, and he gave an answer responsive to it. At best, the state's witness interview summary shows that Cardenas mistakenly thought he knew of someone who had talked about seeing Reed and Stacy together. It does not show that Cardenas lied to the jury or left the jury with a misleading impression about the facts within his personal knowledge. And then Reed argues that Rocky Wardlow testified falsely when he said the year-long investigation into Stacy's death had failed to turn up any links between Reed and Stacy. Here, yet again, Reed failed to make a prima facie showing of materiality. The jury already knew that the investigation into Stacy's murder had failed to turn up at least two people who could potentially link Reed and Stacy. Defense witnesses Julia Estes, who testified that she'd seen them talking at HEB, and Iris Lindley, who testified that she'd seen someone who looked like Stacy come to the Reed house looking for Rodney. Further, even if the jury heard from Susan Hugan and learned about the Ron Haas, Andrew Cardenas, Jose Coronado information, there is no reasonable likelihood of a different outcome. None of those individuals could have provided persuasive evidence of a romantic link, a secret affair between Reed and Stacy. So the finding is that in sum, Reed's complaint about the state's cross-examination of Julia Estes and Iris Lindley, the state's closing argument, do not fall within the scope of a false testimony claim. Reed has failed to make a prima facie showing that Andrew Cardenas gave the jury a false or misleading impression. Also, as for the remaining witnesses, Paul Alexander and Rocky Wardlow, Reed has failed to make a prima facie showing that their allegedly false statements were material. That conclusion holds true even when we assess their potential for materiality in the aggregate. Because Reed has not made a prima facie showing that he suffered a due process violation, Claim 2 is dismissed as an abuse of the writ under Article 11.071, Section 5. And then Reed also has made a false forensic testimony claim in Claim 3. Reed posits that even at the time of trial, the state's expert's opinion regarding time of death, anal penetration, bruise coloration, and sperm longevity had no basis in the accepted scientific literature. Reed therefore argues that the state's trial experts gave the jury false or misleading impressions in each of these regards. Reed points to no post-trial, let alone post-November 2019 advancements in any of these areas. Accordingly, he cannot evoke the Section 5A1 exception for previously unavailable facts. Perhaps understanding this, Reed argues that this claim should proceed past Section 5 because she has shown by a preponderance of the evidence that, but for a violation of the United States Constitution, no rational juror could have found him guilty. Reed therefore asserts that because he has already proven that he is more likely than not innocent of Stacy's murder, this court should consider this claim on its merits. As we explained in our opinion disposing of Reed's -10 application, Reed has not met his burden under Section 5A2 to demonstrate by a preponderance of the evidence that he is actually innocent of Stacy's murder. Reed presents no evidence of innocence in his -11 application. Accordingly, Reed's false forensic testimony claim does not satisfy Section 5A2. Claim 3 is dismissed as an abuse of the writ under Section 11.071, Section 5. Conclusion: Reed's 10th subsequent -11.071 application is dismissed under Article 11.071, Section 5. And that is it. Any thoughts? You're muted. And you're still muted. Kyle. Oh dear. We're apparently having technical difficulties at the moment. Kyle has muted himself, or Kyle's earphones and headphones have failed, or my earphones and headphones have failed. But I don't think that's true because my computer's doing this. All right. Well, folks, I think that's all she wrote. Because all right, Kyle, we're going to call it a day. We will follow up on this episode when we speak next, and that will be what we'll do. Thank you for listening to Based in Fact, a true crime podcast with Lisa O'Brien and Kyle Evans. If you like the show and want to know more, you can subscribe to our YouTube channel, find us on Facebook, or follow me on Twitter at O'BrienLAn. Kyle and I will return in 2 weeks for episode 9, Oklahoma versus Anthony Sanchez. Sanchez was linked to the December 20th, 1996 kidnapping, rape, and murder of OU graduate Julie Buskin via a cold case DNA hit in July 2004. We'll look at the evidence against Sanchez, his trial, direct appeal, and state and federal post-conviction claims, including his recent actual innocence claim, which alleged that its deceased father, Glenn Sanchez, admitted that he was the real killer in statements made between 2020 and his 2022 suicide. Until then, have a great 2 weeks and stay safe.